North Carolina, from the mountains to the sea, it's a place with abundant and diverse streams, rivers, lakes, and wetlands. Federally mandated to manage and protect our diverse waterways and wetlands with a permitting process is the Wilmington District Army Corps of Engineers. However, the Wilmington District Corps of Engineers is just one of the many state and/or federal agencies that an applicant may have to coordinate with prior to beginning their project. The purpose of this video is to help an applicant understand other state and federal laws that may apply to their project besides those administered by the Wilmington District Corps of Engineers, and what additional coordination is needed with other agencies depending on the project. For example, the Corps works closely with the North Carolina Division of Water Quality, also known as DWQ. That's because permits issued by the Wilmington District pursuant to Section 404 of the Clean Water Act also require a corresponding permit issued by the North Carolina Division of Water Quality, known as a 401 Water Quality Certification. DWQ uses the authority granted under Section 401 of the Clean Water Act to manage certain activities that impact their wetland and water resources. This includes the authority to grant, deny, or condition certification of federal permits or licenses issued by the Corps that may result in a discharge to waters of the U.S. Maintaining water quality standards is an effective tool for states to protect overall wetland health and functions. So, for work in waters and wetlands in coastal counties, an applicant may also need to obtain authorization from the North Carolina Division of Coastal Management, or DCM. Section 307 of the Coastal Zone Management Act of 1972 requires that the applicant certify and the state agree that the project is in compliance with an approved state coastal zone management program before the Corps can issue a permit. In addition, permit authorization is required from the DCM pursuant to the Coastal Area Management Act, or CAMA, for activities within coastal waters and wetlands, including permits for development in areas of environmental concern. Activities in North Carolina waterways may also be subject to permit review from the Habitat Conservation Division of the National Oceanic and Atmospheric Administration, which evaluates possible impacts to essential fish habitat. Essential fish habitat refers to those waters necessary for fish to spawn, breed, feed, or grow to maturity. Another area of permit coordination is related to work occurring in navigable waters. Both the Corps of Engineers and the United States Coast Guard have a similar federal responsibility. However, when it comes to coordinating permit applications for matters like bridging decisions, the Corps will defer to the Coast Guard for the structure, but retains responsibility for any approach fills within wetlands associated with the bridge. Also, we may need to coordinate with other federal and state agencies regarding the different types of resources that may be located in or near the property. For example, prior to the Corps issuing a permit, we must verify that the proposed project will not have an effect on any species listed under the Endangered Species Act. So we'll coordinate with the appropriate U.S. Fish and Wildlife Service office as needed to help us make those determinations. In North Carolina, you will find there are more than 60 federally threatened or endangered species to be aware of and considered when proposing a project. Species range from endangered freshwater mussels in streams in the western part of the state to threatened and rare plants in the Piedmont, to red cockaded woodpeckers in the coastal plain. In addition to natural resources, the Corps must also consider potential effects to cultural resources. The National Historic Preservation Act of 1966 requires the Corps to coordinate with the State Historic Preservation Office for projects that might impact any property listed or eligible to be on the National Register of Historic Places. Sometimes properties have never been surveyed for these resources. Accordingly, we'll coordinate with the State Historic Preservation Office as needed during processing of an application to determine if a survey is necessary before proceeding with permitting. In North Carolina, there's also coordination between the Corps and several federally recognized Indian tribes, such as the Eastern Band of Cherokee Indians, Cherokee Nation of Oklahoma, and the United Kiowa Band of Cherokee Indians in Oklahoma. Tribal coordination is required when any application for permit authorization is evaluated within the Aboriginal territory of the Cherokee Indians. This includes both reservation and privately held lands, with coordination being conducted through the Tribal Historic Preservation Office. When a permit application is received, the Corps is not just reviewing the proposal based on our own regulations and policies, but may also need to evaluate the project based upon impacts to other resources on the property. These were just a few examples of some of the other agencies the Army Corps of Engineers might need to coordinate with when evaluating permit requests. We hope you found this helpful, and please visit our website for more information on these topics, such as more in-depth videos on endangered species and cultural resource issues. Also, visit our website for current links to our state and federal partners. Thanks again for watching.